Most people don't realize it, but the moment a police officer calls a K-9 unit to your traffic stop, you have one window, and one window only, to protect every single right you have. Miss it, and that dog decides your fate. Use it, and the law stands completely in your corner. These exact words, said in the right order, at the right moment, are the difference between driving home and being arrested on the side of the road. I've spent years breaking down exactly what the courts say about K-9 stops, and what I'm about to walk you through is the complete legal playbook, the sentences, the sequence, and the Supreme Court decisions behind every single one of them. Subscribe right now, because this channel is dedicated to giving you the legal knowledge most people only get after they've already been arrested, and we're dropping new videos on your rights every single week. Here's the reality that almost nobody tells you. A K-9 unit being called to your traffic stop does not automatically give police the right to search your car. That is not how the law works. But if you sit silently, say nothing, and let the situation unfold around you, the outcome will almost always look like it does. Most drivers treat the moment that dog steps out of a patrol car like a verdict. They freeze. Their hands shake. Their brain goes blank. They say absolutely nothing. And in doing so, they hand over every legal protection they had, not because the law abandoned them, but because they never activated it. Let me paint the picture most drivers are living without knowing it. You get pulled over. Maybe it's a broken taillight. Maybe you are going a few miles over the limit. The officer takes your license and registration, runs your plates, walks back to your window, and then doesn't send you on your way. He tells you to sit tight. You watch him walk back to his car, pick up his radio, and 2 minutes later a second cruiser rolls up. An officer steps out with a German Shepherd on a leash. Your stomach drops. Your chest gets tight. You have no idea what to say. So you say nothing. That silence, that exact moment of saying nothing, is where your legal defense either begins or ends entirely. Here is where you have to change everything you thought you knew about traffic stops. That 60-second window before that dog ever reaches your car is the single most legally powerful moment of the entire encounter. What you say in those 60 seconds determines what your attorney can do for you later, what a judge will consider, and whether evidence found during that stop can even be used against you in court. It is not about arguing with police. It is not about making the situation worse. It is about activating constitutional rights that already belong to you before the window closes. The very first thing you need to do the moment you see that second cruiser or hear that a K-9 is being called is establish your detention status out loud. You roll your window down slightly, you look directly at the officer, and you say this clearly and calmly. Officer, am I being detained or am I free to leave? That is it. 10 words. Officer, am I being detained or am I free to leave? Write that down. Because those 10 words do something most drivers never think to do. They force the officer to make a legal declaration on camera. If he says you're free to leave, you ask for your license and registration back, you thank him, and you drive away. The dog never gets near your vehicle. But if he says you are being detained, he has just legally committed on camera to having reasonable suspicion to hold you. And that commitment comes with a constitutional clock. He cannot keep you waiting indefinitely for that dog to arrive. The detention must be justified, and it must be proportionate. That question is what starts the clock. The legal foundation here is Rodriguez versus United States, decided by the Supreme Court in 2015. The court held that police cannot extend a completed traffic stop, even by a single minute, for the purpose of a dog sniff without independent reasonable suspicion. In plain language, once the officer finishes the reason he pulled you over, the stop is supposed to end. He cannot manufacture a reason to hold you there while waiting for a dog to show up. Your question forces that issue into the open the moment the dog is called, not after the search has already happened. Now the second tactic, and this one is the one most attorneys say matters most after an alert happens. The moment that K-9 officer walks toward your car, before the dog is anywhere near your vehicle, you say these exact words out loud, clearly, calmly, and on camera. "Officer, I do not consent to any searches of my vehicle or my property." That sentence. Every single time. Not in your head. Not implied by your body language. Out loud, on camera, so there is no question later about what you said and when you said it. Because here is what that sentence actually does. If the dog alerts and your car is searched anyway, your attorney now has documented non-consent on body cam footage. That is the foundation of a suppression motion, a legal argument that the evidence found cannot be used against you because the search was conducted without your consent and potentially without lawful authority. Without that sentence on the record, the prosecution can argue you were passively cooperative. With it on the record, your attorney has something concrete and real to take into court. The Supreme Court case backing this is Schneckloth v. Bustamante from 1973. The court ruled that consent to a search must be voluntary, but critically, officers are not required to tell you that you have the right to refuse. Plain English, they are not going to tell you that you can say no. But you can say no. And saying it out loud on camera is the entire difference between a case your attorney can fight and one they cannot. This is 100% legal. You are not obstructing. You are not being hostile. You are exercising a right that has been recognized by the highest court in this country for over 50 years. The third tactic is the paper trail demand, and this is the one that almost no driver ever thinks to use in the moment. As the K-9 officer approaches, or when the officer returns to your window after an alert, you say this: "Officer, can I have your name and badge number, please? And can you tell me the specific reason I am being detained?" That's it. "Officer, can I have your name and badge number? And can you tell me the specific reason I'm being detained?" Here is why that works so powerfully. Asking for a name and badge number is completely lawful, and it immediately signals to every officer present that you are creating your own record of this stop. Asking for the specific reason for your detention forces the officer to state reasonable suspicion out loud on camera. If that reason is thin, vague, or shifts at any point during the stop, your attorney will catch it on the footage. Any inconsistency in the officer's stated reason goes directly into the legal challenge. What sounds like a quiet, respectful question in the moment becomes a critical piece of your defense later. The legal backbone here is Terry v. Ohio from 1968. The Supreme Court ruled that police must have specific and articulable facts to justify detaining someone. A feeling, a hunch, a general suspicion, none of that is enough. The officer must have real, specific reasons. Asking him to state them out loud on camera is not aggression. It is you making sure those facts go into the record exactly when it matters most, which is before the search, not after. Now tactic 4, because the situation will escalate, and you need to know exactly how to hold your legal position without breaking it. When you have already asked about your detention, already stated your non-consent, already requested name, badge number, and reason for detention, and the officer is still pressing, still telling you the dog alerted, still suggesting it will go easier if you just let them look, you do not engage with any of that. You go back to what you already said, and you say only this: "I am already stated I do not consent to any searches. I would like to speak with an attorney." Those two sentences back to back. Nothing more. "I am already stated I do not consent to any searches. I would like to speak with an attorney." Once you invoke the right to an attorney, the questioning is supposed to stop. Anything obtained after that invocation becomes extremely problematic for prosecutors. You are exercising your Fourth Amendment right against unreasonable searches, and your Sixth Amendment right to counsel simultaneously. Together, those four tactics, the detention question, the verbal non-consent, the name and badge and reason request, and the attorney invocation, form a complete legal record built in 60 seconds on the side of the road. Let's run all four of them through a real scenario, so you can see exactly how this looks from beginning to end. It's a Friday night. You get pulled over for allegedly drifting slightly over the center line. The officer takes your documents, runs your plates, comes back, hands over your license, and then doesn't send you on your way. He tells you to sit tight and walks back to his car. 2 minutes later, a second cruiser arrives and an officer steps out with a dog. The wrong way. You sit in silence. The dog walks the perimeter. The dog alerts near the trunk. The officer announces probable cause to search. Your car gets torn apart. Anything found gets used against you. You had no documented refusal. You asked no questions. You created no record. Your attorney has nothing to anchor a challenge to. The right way. The moment you see that second cruiser, you lower your window slightly and say, "Officer, am I being detained or am I free to leave?" He says you're being detained. You now know the clock is running and the detention must be justified. When the K-9 officer approaches, before the dog reaches your car, you say clearly, "Officer, I do not consent to any searches of my vehicle or my property." Then you ask, "Officer, can I have your name and badge number, and can you tell me the specific reason I am being detained?" He answers. Whatever he says goes on camera. The dog alerts. The officer announces probable cause. You say, "I have already stated I do not consent to any searches. I would like to speak with an attorney." And then you stop talking. You do not argue. You do not yell. You sit calmly and say nothing further. The search may still proceed. Probable cause from a dog alert can override your verbal refusal in that moment. But what you have now is something completely different from what most drivers leave a stop with. You have a documented detention question on camera. You have explicit verbal non-consent on camera. You have the officer's stated reason for detention on camera. You have an attorney invocation on camera. Your attorney now has 4 separate legal hooks to challenge the legality of everything that followed. That is the foundation of a real defense, built entirely in 60 seconds on the side of the road. Next week, this channel is releasing the full breakdown of what to do when officers claim they smell marijuana as the justification for calling a K-9 in the first place. That specific tactic is used in hundreds of thousands of stops every year, and the legal counter to it is something almost nobody knows going in. Subscribe right now so you do not miss it, because that video connects directly to everything you just learned here, and it is the most important one in this entire series. Here is the quick version of everything you just learned. The moment a K-9 is called, immediately ask the officer whether you are being detained or free to leave. Before the dog reaches your car, state out loud that you do not consent to any searches of your vehicle or your property. Ask for the officer's name, badge number, and the specific reason you are being detained. And if the pressure continues, tell the officer you have already stated your non-consent and you would like to speak with an attorney. For sentences, 60 seconds. That is the entire system. These are not tricks. They are constitutional rights backed by Supreme Court decisions, Rodriguez, Schneckloth, Terry, tested and upheld for decades. Your only job is to activate them before that window closes. If this video showed you something you will actually use the next time you are pulled over, subscribe to this channel right now. We cover your rights, how the law actually works on the side of the road, and exactly what to say in the moments that matter most. Drop a comment below telling me whether you knew about this 60-second window before today or whether this is completely new information. I read every single comment. Stay sharp, stay calm, and I will see you in the next one.